Okay, we want to call this Strategic Planning Committee meeting for Monday, August 4th, 2014 to order. The invocation be led by Mr. Johnson.
Heavenly Father, Son, Holy Spirit. Heavenly Father, grant us the wisdom and the guidance to make decisions for the betterment of the people of Ascension Parish. Watch over us in this hurricane season. Keep us safe from harm. In Jesus' name we pray. Amen.
Amen.
I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, Ms. Cazzo's not here at this time. Everyone else is here. She was in traffic, as I know a few of us are. Public comment period. Anybody wishing to speak on any agenda item, please sign up over here, and you will give given your time at that as that agenda come up. Number 4, update on local alcohol license requirements application. This is just a follow-up on what we had been talking about for a councilman that has to approve alcohol license application. And to little FYI, we had been given one page to look at, and the basic application was filled out, and they had a place for the signature for the councilman, and we were not given any background information as to whether they had been through the sheriff's office, through the taxing authority, or any of the past investigations. So, Jessica, can you want to summarize what we're going to be getting now?
Now the Mark West and the taxing authority, they're going to send us the Schedule A, which has everything on it. It has the sheriff's signature, it has the taxing authority signature on it, it has everything. So that way you'll know for sure that the sheriff's office has looked at it and they've signed off on it.
Okay, so basically you're going to get the background information, and of course it'll be confidential, and then you can base your signature on something that you have some background. So that's what we were looking to try to make sure everybody got the proper background. Any questions or comments?
Mr. Chairman.
Mr. Lambert?
And I think the main thing we was trying to do also was to streamline, make sure that the efficiency that was going to be pretty quick with this.
Well, and one of the things is that they had a sign off or not sign off, and no one knew whether they investigated.
Okay.
So what the councilmen were doing was going out and trying to get background information, and most of the time it was already done, so we were wasting time.
Okay.
And
great,
we're
yeah.
also going to start emailing. When we do get an application in, we'll start emailing them to everybody, because that way you can get it, and if you can scan it, you can send it back to us. So that way that'll make it a little more efficient also.
So I think it'll be quicker. And
Mr. President.
yes.
Originally, the council chair would sign off on the applications. When Mr. Bell was chairman, he designated that the councilman in each district could sign off on them, but it's still not clear. Maybe we need to clarify that part too, as to, okay, do you want the council chair, do you want each individual councilman to sign off on the application? So
In practice, what had been done is that the individual councilman in the district signed off, and if in their absence, the chairman could sign. If anyone wants to change that, that's fine.
No, I think we need to leave it.
But the consensus, Council, Mr.
Yeah, I'm not trying to change the status quo because I like it, but I'm just curious. On item number 16 under the Ascension Parish Sales and Use Tax Authority report that we're previously getting, and by the way, Jessica, I have great appreciation that we're also going to get now the Ascension Parish Sales, the Schedule A, because that'll help on the policing part. But it says council member signature, so I don't know about the history that President Martinez is talking about, but that language is, to me, sufficient enough. It doesn't say chairman, it just says council member, and I would support, I would support what Mr. Bell said, my predecessor, that, this is probably a more important responsibility of individual district councilmen than to blanket it at the chair's level. Chairs change as well with elections and so forth, so
This is just,
I support keeping it status quo.
yeah, and it's not really anything we need to vote on, it's just a procedure, unless somebody wants, it's just paperwork, so. This was just something that secretarial staff, if they didn't have any objection, if we had a consensus, we would just, move
Right.
forward with a little
Good.
more paperwork.
Right.
Yes, sir.
And one more comment that I had last time, I don't know if that's, I haven't studied this maybe as well as I should have, but the idea of getting someone else's, another councilman's, because of, remember the issue of a geographical border that's shared, it's like in my case, Bluff Road with Miss Casso, or the Airline Highway with Chris Lore, et cetera. Has been any thought or change to the document we do get to where we're sure it's District 4 or not? So we're not signing things that we shouldn't be signing
Well,
about other councilmen?
technically, if the domicile is within your district, you are responsible for it. Now, if you would like to get.
No, I mean, I understand that part. I'm just saying, sometimes, it's a boundary, and your district is on the odd numbered side of that street
Oh.
versus the other person's district is on the even numbered. And I've gotten 2 or 3 of them like that in the last couple of years that were on 61. And I'm just an aging guy. I cannot remember odd and even, and I get it, and I'm about to do it, and then I look at a landmark and look at it and go, oh, that's Chris Laws, that's not my responsibility. So is there some way we could address that?
Well, we use, on our website, we have the council districts. That's what we put in the address normally in there, and we look, but it's hard to tell because sometimes the little arrow is not exactly on where it is. So usually what I do, I go into Google Maps and look for it. Look for landmarks, look for where it is, and then that's usually what I do. That's what I've been starting to do, because it is hard to tell where exactly it is, on what side of the street, or, just by looking at on our website from the council district. So I use Google Maps is usually what I do, is what I started doing, because it is hard to tell.
One way, by the way, just a suggestion that would remedy it, if you look up on the voting rolls, street address, if it's on a boundary between 2 districts, would it not give you the correct district right there?
That, yeah, I'd have to
Well-
look at that, yeah. I'm not really familiar.
Yeah,
with
I would
looking at
urge
that
each
one, yeah.
councilman to take a visit to the site.
Yeah.
Well, actually, I would throw that. That wouldn't work, because that's
that's
a
the owner-
person versus owner
Right,
of business.
business locations, too.
Yeah.
Just double check it as best you can, I guess.
That's usually what I do. I just double check myself on Google.
I just
or
wouldn't
our
want to sign
maps
another
and-
councilman's
Yeah.
Go visit.
business. All right. Thank you for your work.
Okay. That's it, we'll move on. Number 5, proposed revision to ordinance, Chapter 5, Animals and Fowl, Article 3, Animal Control Division 4, Impoundment of Animals. Mr. Blanc, Animal Control Director.
What this is asking the council to amend the dangerous dog deal, where often we have to go to court on specific dogs. Not many in the course of a year do we go before them, but it gives the judge some latitude on requirements. Before, there was no requirements as far as a cage being built, a particular type of cage. And what this does, after having some conversation with some of the judges, and this is taken from the East Baton Rouge. They implemented this some time ago, and what we want to do is implement it also into our ordinances. And with that said, y'all have a copy up there? Y'all see what it is?
Yes.
What it is to build a specific size cage that these dogs can be contained in, and a tag put on them, and certain requirements for these particular dogs. And that's what we're asking for.
And basically what's happening, after that dog is deemed a dangerous dog by the judge or entity.
Well, what the judge will do is at his or her discretion, they'll give them X number of days to implement this cage.
Right.
And then if they don't meet that criteria of those days, then the dog is turned over to animal control.
Yeah.
And then that's up to us to handle it from that point forward.
These are dogs that have been deemed dangerous, and as it is right now, they would just be confined to the backyard where it's so-called fenced, but there's no provisions for
Well,
having secure fencing, and therefore
Basically,
the danger.
signs.
Yeah.
Signs
So-
are put up, to basically say we have it beware of dog. And these dogs do have the potential to maul and kill when we go to court on these particular dogs.
Any questions, comments? Mr. Satterley?
Thank you, Mr. Chairman, and thank you, sir. I just have two informational pieces here. I'm not in any way against this new ordinance. In Exhibit A, under subpart B, after having handled in A the fact that the dog that is deemed dangerous, quote unquote, has to have this collar tag affixed, and that assumes that the dog's going to wear the collar, of course, all the time. Of course, the dog may not have it on, so B I like because it's a microchip, and he's got to carry that around
Right.
at the owner's expense. But unlike A, if he doesn't come get a tag from you, from the Animal Control Center,
He won't get the dog. What we'll do is under a dangerous dog, when we already have that dog in confinement.
so it'll be chipped at your facility.
No, he'll be chipped at a veterinarian clinic.
But you'll have some paperwork that says, and they'll report the
Well,
number back to you?
we escort the dog to.
Okay, fine.
to
So at the
make sure
parish level,
all these things are done.
Right.
We won't release the dog till the cages are built, and when they take the dog to the vet, we'll be there to make sure that it's chipped. And that's for, with the collar, there's a big old tag that goes on it that says it's a dangerous dog, but that owner could take that collar off and that dog could get off. and
so
still be
that's
out.
more directed to the dog owner that you're gonna have to do this, not it's
Absolutely.
dangerous, as opposed to us saying, like, you know, people are gonna look at this and say they're trying to make $5 for this or 10, and that's absolutely crazy, by the way.
This is
I'll
for
just say that.
identification
But
purposes.
yes, and they have to do it because you're not gonna release the dog.
That's
Okay.
exactly correct.
Okay, then the other question I had was on K, on the second page of Exhibit A. The owning, keeping, or harboring of a dangerous animal in violation of this title is deemed a public nuisance. And I focus upon the word public nuisance. What really is the meaning of that? And if you're a public nuisance, so what? What can we do about that?
Well,
And I-
the verbiage that's put in there, the legal terminology, is what they chose to use. And I'm assuming the owning and keeping and harboring of a dangerous animal, that's what we're talking about. We're not talking about a nuisance animal. That's just part of the verbiage they use, that's nuisance.
Does this also, though, have legal meaning to I was talking to President Martinez about this before we went on air tonight, to not just the dog, but the dog owner? The dog owner is harboring a vicious, dangerous
Well-
animal deemed so by the court or whatever. So now it's public nuisance. I just want to ensure, I see a lot of ordinances out there, sir, where, you know, if you're the owner
Right.
and you got a bad dog and it bites sometimes, in a lot of places, there's laws where you can go to jail as well as,
Well, this is what
confiscating a dog and
some of
using
the
it on him.
specifics that goes along only with the dangerous dog part. It doesn't fall under the regular running at large or whatever.
Okay.
That's some of just the legal verbiage that goes along with this particular ordinance. The dog is more than a nuisance if it's dangerous, okay? But I'm sure in the legal verbiage, there's some definition as to for why they put.
right. And so for the public that's watching out there tonight, this local ordinance, if we recommend this to the council and they pass it and it becomes law in our parish,
Right.
nothing in this, because we're not reading all sections A through N
Right.
of the whole, what do you call it, attachment here, would ever, at our level, say that a person that had a dangerous dog like that, we have the power to put you in jail. There's nothing in here that says that.
That's up to the police department.
No, but
Well, when you say we have the power to put
I
somebody
understand,
in
but from
jail,
what I read, there's no language in this. I want the public to know that we're not voting on something tonight that says we can come put them in jail, are we? If so,
No,
Okay.
that's a call on the police department
all right.
and the attorney.
Right, well, I mean, they have to interpret this law, though.
Right.
And
Correct.
what I'm saying is, I don't see, I'll take
Right.
that responsibility, anything.
Right.
I was looking for you maybe to say, I don't see anything either, but it's a safe position to always say,
Right.
let's let the law take a
This
look
is
at
strictly
it.
about the dog.
Right.
And the owner's responsibility once it's deemed dangerous.
I thank you.
Explain, everyone, what are we considering a dangerous dog? Does it have to bite somebody? Does it have to
It-
growl at somebody, or what?
No,
What
no,
is the?
once it's bitten, it goes before the judge, okay? And, we only run into, there's a lot of bites that we have during the course of the year. I mean, and most of the bites are to children, okay? And, once he's bitten somebody, and you don't wanna say that a dog of a particular size, weight, or whatever, there's a character of his age, you can't characterize, just like a judge does, if you're big, small, or whatever. But obviously, there's pit bulls, German shepherds, and Doberman pinschers that pose an extreme threat to the public, and they need to be addressed. And that's what we're trying to do, is to take this element of death and injury out of that. And there are times when particular owners don't see it. They just don't see it as being dangerous, so it goes to the court, and the judge makes that decision. And then when that decision is made by the judge, we need to have something in place to make sure that these animals are contained.
So, I got a follow-up to that, Kent.
Yes.
Yeah, well, thank you, Mr. Chairman. So I think the president brings out a very important point here. I want to be sure I thought I understood it. So the characterization of the dog as, quote, dangerous, unquote, is not something at the parish level we would say, or through animal control or even through our sheriff's
There's a
department.
state law that covers that.
So it would be a court of law judge
Exactly.
stating it's dangerous. So do we need anything in our ordinance that indicates the definition? I think, and I
There's a
see Mr.
sta-
Martinez nodding his head yes, that we define what a dangerous dog is, that it's a court of law says it's dangerous?
Yeah, the code of law states that there's a state law that says the dog is dangerous.
Right, but do we need in our local ordinance, in your opinion, something that defines what a
We already
dangerous?
have that. What we don't have is,
To transport the dog to get it tagged is what they.
well, that's what I stated, a dangerous dog is it showed the potential to bite and has bitten.
Yeah, but you're stating
you
that
can
verbally.
say-
It's not written down what a definition of a dangerous dog is here, but I think.
No, you
Benny's got it.
misunderstood me. I think anyway, or maybe I presented it wrong. When a dog is declared dangerous by the judge because it fits the criteria of being dangerous because it is bitten and caused injury, what we are asking as on this amendment is, what we added in was the part C about how to build a cage to contain a dangerous dog.
Okay, let me just do it this way. The very first sentence says, and I quote, "The owner of a dog that has been classified as dangerous." Our ordinance doesn't say who did that classification. That's all
The judge.
Judge.
Judge is gonna do that.
So could we say the owner of a dog that has been classified dangerous by a judge in a duly blah, blah, blah?
Only a
court of
judge
law?
can do it. We
Yeah,
can't classify a dog.
We don't have the authority. to
No, I'm not asking to do it. I'm just saying on a dog that has been classified by, dangerous by the judge, not us.
You asking for that verbiage to be put in?
Yes. So it defines a dangerous dog. It's now defined as what the judge says is dangerous.
Lindsay, what,
There's a state law.
There's a state statute that goes into detail about what the dog has to do in order to be considered dangerous. And so if we file a lawsuit, we'll go before the judge and say, Judge, this dog meets these certain criteria as laid out in state law, and whether or not the judge agrees with
Right, but
it.
how do we force them just to go ahead and put the tag and all this other kind of stuff, build this enclosure that's in here? We haven't even discussed
Putting
that.
this ordinance in.
we
This
put
is
it,
this is giving the judge something, not only to declare the dog dangerous, but to say, you need to take these precautions. We're gonna let you keep your dog, we won't force you to put him down, but in order to do so, you need the tag, you need the microchip, you need the,
pin.
the specific kennel built for a
Okay,
certain
that's
strain.
better. So now the judge has more teeth than he or
Right.
she formerly
Yes.
had, and can say it's dangerous, and not only that, because of the ordinance of this parish, be sure you do the following
Right, correct.
things. Build an enclosure, have it tagged, have it microchipped. If you take it out on a leash, it's got all kinds of things in here. It's got to be of a certain length with a certain type of muzzle and,
Correct.
okay. All right. Thank you.
any other questions, comments?
Mr. Chairman, if you don't have any other.
Got a couple of spelling corrections on there. I don't know if you want to put that in there.
On which one,
F.
Denny?
Jessica, if you look at item F on there, there's a couple of spelling corrections. It says the Animal Control Center, its discretion. I think it should be at its
At.
discretion.
Okay.
And then dangerous is misspelled as well in that same sentence, so just make it grammatically correct.
Yes.
But
Mr. Chairman, with those corrections, I'll go ahead and make a motion for this to.
Moved by Mr.
Second.
Lambert to adopt this, send it to the council, second by Mr. Johnson. Any questions, comments? Any objections? All right. Jessica, move that on to the next council meeting. Family petitions.
Thank you. Mr. LeBlanc?
Thank you, Mike. Appreciate
sir.
everything you do. Next thing is 6 family petitions, loopholes. There's been discussed by the people in the parish and Broughton, especially lately, number of situations where we had, even though we don't have many family petitions, we've had some loopholes where it allows people through numerous family petitions to skirt around the intent of that and create subdivisions, and by having multiple family petitions for the same property. And we were trying to keep that from happening and have these larger developments also follow the drainage and traffic requirements and all that any other subdivision would have. Some proposals were sent forth. This has been some of the suggestions that have been discussed with some of the planning commission members and Ricky Compton, so he sent this to us to take a look at. Some of the suggestions as to what's being discussed. We would ask, this is for information purposes today, take a look at it. Please, let's get some suggestions, some hard suggestions on what you would like to see, and we will try to assist in moving this forward. And the reason being is, and I spoke with the chairman of the planning commission, and they're talking about a moratorium until we can decide something. I don't know if that's going to follow through, Mr. President.
That's what I was going to say. It's on the council agenda Thursday.
Right.
For that the planning commission had asked for a moratorium of 3 months to look at the ordinance and to come back with recommendations. So that's just informational.
Right. So, that may come forth. It's something that we need to go ahead and act on to try to close the loopholes that everybody sees is there, and we've been knowing about it for a long time. It's just been hard to legally close these things in the proper manner. So, unless somebody wants to move quickly on it, we would like, I think we have enough time if we need to call a special meeting. But I would like to make sure everybody knows and had a chance to discuss this with Ricky and legal about what the implications of each thing is. General consensus with talking to different people, getting information. People talking with myself has been that they just don't want to see family petitions done over and over again. Want to welcome people to have their family petitions and do that. We're one of the unique parishes that do offer. We want to let people know this is a variance from what a vast majority of parishes do not offer. And so it's something that's unique in Ascension Parish. No one wants to keep people from giving their kids their land, and but we would just want to close some of the loopholes. Benny?
And we're having conversations about this before. I think one of the things that's important about this, to me, is that whatever we come up with for these loopholes, that it's enforceable and trackable. I mean, if you're gonna make changes to it to where we try to close these loopholes, I would like to see something in it that, no matter what it is, because like you said, we are one of the few that offer this thing. A lot of people quit doing it because of the troubles that were inherent with it. That, to me, it's got to be something, again, that we can track and we can enforce. Because if you can't do that, then you're not closing any loopholes. And so as much as we want to do this and keep this a viable option, I think we need to make sure we focus on that part of it as well.
Okay, I've got that down, Benny, I'll talk about to legal. Yes, Ms. Terry.
Thank you. I would just like to see clearly explained how these loopholes happen and what's the consequence when they happen, so that the public is aware of why we're taking this on at all.
But basically, in a nutshell, what happens is Joe Blow comes with 20 acres of property, and they have 3 children and grandparents, a father or mother or whatever, and they come for a family petition, and they divide that 20 acres into 5 lots, which is perfectly legal to do so. Give some to their kids, some to their parents, and so on. Then, the next year, come back and take one of the 5-acre lots that they had and divide that into 5 more lots. Now it becomes 10 lots, and the next year they take the next 5 acres and divide that into 5. So you end up with a 10, 15, or 20 lot tract that was initially had without any drainage requirements, sewer, anything else.
Water, any of it.
And so people are being, developing things, and then the guy next door has 20 acres, and he has to follow all the guidelines through drainage and everything. And as people know nowadays, with the drainage situation as it is, for somebody to develop multi-lot housing next to you, drainage is very important, and so is traffic, and so we want to make sure that it's done properly. And again, no one wants to keep someone from giving family property, which was given that. But we have, as it is right now, people are buying property this year and turning around and selling, doing family petition next year for the sake of doing that.
And so just, as I understand it, just for sale signs are popping up on these
Yes.
divided properties, and actually this is just circumventing the rules
The intent
around
of the-
the intent of the subdivision ordinances. Thank you, Ken.
Yes, Mr. Mr.
Yeah, thank you, Mr. Chairman. I have appreciation for what both Terry just asked for and what the president had to say. And so I'm not against the fact that we probably need, not probably, we need to fix loopholes per se. I guess I have angst, though, with, don't we need to get, Mr. Chairman, this language of 174026 through this committee, strategic planning, before we ask, for example, we all got our agenda today, a moratorium on family petitions at the full council level. If this material is coming up either from our planning department and/or planning and zoning commission, and we've got some language before us here, I think we need to honor all the details of it, because while I'm not against closing the loopholes, I do have at least 2 points and potentially a third one that I would like to cover before we do anything. I don't want to use the word radical, but because it's not radical at all. But before we change law, or even say, look, let's stop all family petitions till we can decide out how or if and when we're going to change law. In other words, if you want to entertain the 2 that I have tonight, I'm willing to do that. Or if it looks like we're headed to a deferral back to this committee again, I find some of the language a bit unreasonable. I wrote down the 3 ons, a little bit unacceptable in spots, and then, quite frankly, there may be 1 sentence or 2 that is borderline unconstitutional, and I have called a constitutional lawyer friend of mine who called me just this afternoon and said that he was unable to look at my original request, which was back on the 28th of last month, to take a look at this proposed language that we have before us here today, but that he would be looking at it today, and likely by tomorrow will give me his frank opinion. So if it's the wish of the commission to defer it, that's fine with me, or if it's the wish to hash it out right now and try to decide whether we're going to bring this as a recommendation, in which case.
What we're looking for is to get general concepts so that we can send it to legal so that the written verbiage can be corrected.
So I have 2 concepts right now. Do you want to cover them tonight? Or you want
Yes,
to
sir.
wait?
That's just
Okay.
anything that's what we're
All
here
right,
for.
let's look then at 174026, where it says family petition subpart A. The comment in there about 3 years. Basically, I guess, question, and it may be a good reason for this, but why do we have 3 years ownership language in that first paragraph? That seems arbitrary to me. Why not just leave it at January 1st, 2015 and be done with it?
Where is that? Excuse me.
It says, family petition shall only be considered if the applicant has been the owner of the property since January 1st, 2015, and has owned the property for a minimum of 3 years.
Well, and the reason for that is because the intent of that is for people who have owned family property. It's a variance. Anyone that buys property today and wants to turn it into a subdivision has to go through our subdivision regulations.
I understand, but suppose that...
If the exceptions, the variance would be that people that had family property that would want to donate to their kids. If you had family property, then I think by definition, everybody would think that you would have it for a longer period of time than 3 years.
Yeah, but suppose,
And that's what-
suppose we put this into law January 1st, 2015, and I own something for 2.5 years and not 3.
Then
I'm just caught in the middle of this. I mean, why not just say January 1st, 2015, and get rid of the loopholes that are coming and just be done with it?
It can be done that way, but the intent of it is try to keep limited to family petitions, and remember, this is a variance. This is not something that is inherited. You can divide the property up
Right.
immediately. and
I'm
go
not,
through the
I'm not
property.
questioning, I'm not questioning that at all. I'm just questioning the 3-year ownership language as it relates to, this whole section is family petition. So, again, I just,
So you would like to see it
January
have
1st, 2015.
For no time, January 1st.
the 3 years is just, it's arbitrary in my mind. The next point, Mr. Chairman, I'd have is that under A,
That'll be
point
a
one,
discussion.
point small a, capital A, 1, small a, it reads, if property limits were changed by simple division, the property is no longer eligible for family petition.
Right.
I disagree with this. As a former planning and zoning commissioner, I've seen some examples of this. Whether the property limits have been created through simple division or not, either case should have no bearing, in my opinion, on the property division through family petition. And so I'd like someone to clarify that point to me, but let me give an example of why first. For example, consider, you used an example a minute ago, let's say I have 20 acres of property, and it has adequate road frontage, and it has been simply divided into 2 10-acre parcels, those parcels being parcel A and parcel B. The owner of tract A then wishes to give, and you could have 2 different owners at that point after the division, 3 of his children, each 1 acre property, but he does not have adequate road frontage to create 3 different or new lots. So he qualifies for a family petition as the law is written now. However, with the family petition language of A.1.A in revision, he no longer qualifies. Do we really want that to happen?
Wouldn't bother me in the least bit,
It would bother me.
you know.
So it's,
I mean,
again,
because what ends up happening is somebody has 10 acres, and then they do a simple division of property so they can make 6 lots instead of 3. And that's what's happening. It just, the facts of the matter is, people are taking advantage of.
well, when you say the
these
people,
things.
there are some doing this, but there are some people that are not. And like I say, a person that's of good intentions, it would preclude them for doing a family petition that they would normally have. And then my third point is, if you look under subpart B, point 2, it says, under no circumstances shall the owner of the parent tract, as defined on January 1st, 2015, own more than 1 lot within the limits of the original parent tract. I also disagree with that language, not all of it, but the part that says under no circumstances, quote unquote. I believe there needs to be clarification if this language pertains only to the time of the family petition in which it's being requested. Here's the example. For example, consider the case of when a parent would give a child a piece of property and the child falls on hard luck, gets into hard financial times, difficulties thereafter. If we adopt family petition B.2 and it becomes law, then the parent cannot assume ownership of the property to try to help that child out and keep that property in the family. I believe, again, that would go against the original spirit of the family petition ordinance. Now, the next language says no property owner shall be allowed to donate property to the same family member more than once, through the family petition process, regardless of location. I do agree with that, since there are other mechanisms in place to divide the property, which the classic example would be simple division, and donate, it to family members. But the first part underneath 2, the under no circumstances language, I have a difficulty with that as well.
And we'll bring that up.
Question
Yes.
on that. But under, Dan, under that example that you put there, would it not be possible for that person to sell that tract to another sibling? May not be able to sell it back to the parent or give it back to the parent, but you could do the same thing with another sibling, correct?
Well, I think
And
so,
that would
but,
solve that.
but that may not be the will of the parent to start with. I mean, I'm not sure we should start abdicating rights of divided property to siblings and things of that nature. I mean, I can just hear my phone ringing saying, Doc, how did you support this? And you prevented me something that I've been able to do, and I'm not the bad guy. Look, I've said it and I mean it, guys. I like to work with this committee and all through the full council. There's loopholes out there, and for those people out there that are doing the things that Mr. Schexnayder described in his initial statement, we should just stop and we wouldn't even have to have this discussion. But I want to be sure that we don't infringe upon the rights unreasonably or unacceptably. And again, I really don't want to do a whole lot until I hear back from this constitutional scholar of mine, because, you know, this can sound real corny, guys, but it is what it is. You know, the Declaration of Independence says we have the right to life, liberty, and the pursuit of happiness. I've said this before on quick take expropriation and other places. The original document said life, liberty, and the ownership of property, which our forefathers considered happiness. And so when you start dividing up people's property by a mechanism we've had forever and ever with a, quote, spirit that I guess everybody was paying attention and doing it within the correct spirit of the law, but now they're not, whatever's happened here, I want to be sure that we still do not take away the rights of people who legitimately want to be given pieces of their property to their children while we attempt to close these loopholes. And I'm just going to borrow from an expression, Kent, that you once said, and I like it. Let's not throw the baby out with the bathwater.
Mr. Kluwat, he's in the audience with what? In the Grand State of
Now
Santa
I'm in trouble.
Thank you, Mr. Chairman and committee members. Hey, on the family petition, I've always been an advocate of the family petition. I think we have 3 out of 11 council members right now that, for sure, 3 out of 11 anyway, that live on family land. It was a great thing that my dad was able to give land to me and the rest of my family. I know that we've outlived some of the things that we could let go of 30, 40 years ago. And one thing that I think all of you guys up there right now are very much intent on, the reason this is here is because we do have some people that will look for any loophole in the law to get done what they need to get done, you know, to better themselves. Within the family petition, Lindsay Manda can attest that within the last year and a half, we've had somebody that, you know, request a family petition on a piece of land, request to break a piece of land up, and then the next day it's for sale. I think we have a member of our administration in the planning department that ended up buying a piece of land and built a house on that was a family petition land from somebody else's family probably shortly before he bought it, you know, before he came here, you know. So you can see the abuse. I just want to clear up the fact that from what I understand, that the family petitions is less than 1% of the property movement, okay? So, or maybe 1, but 1 to less percent. So while it does need some looking over and some changes made, and we got a good planning commission and a good board right here out of you guys that'll come forward with things. I'm not opposed to the moratorium, that we can take a look at everything. But I just, while it is a law that's being abused, it may not be the most abused thing that we have in the parish. Mm-hmm. And I would like for everybody to take a good close look. Some of your comments, Doc, some of yours, Benny's, and Terry, that let's take a look at where we're going, because where we're going, we're going to draw some lines, black and white, on the page. Take the gray areas out, and it's going to affect somebody somewhere. And I still represent a pretty rural area, but I mean, each one of us, even it don't matter which 11 members, somebody has some rural area, has some family land. There's still some big chunks of family land out there, So let's just proceed with caution. And I thank you guys for your time.
And He wasn't here whenever we started. Todd, do you want to make a comment? Because this was a discussion that was brought up at the beginning, and I think it's been affecting.
I agree a lot with Randy. You know, he's from a large family. I'm from a large family, and you know, there's still some land in the rural area. Maybe, like you said, giving it to, letting them turn it over one time, do a one-time family petition may work, but I'm cautious too. I'm not sure about a moratorium, because I'm getting some calls now that they got a lot on the books, family partitions, that's true family partitions coming forward. So, I'd hope the committee can move a little faster. Planning Commission could come to us, you know, within a month or so and come with a resolution, you know. A 3-month moratorium could cause some hardship on some people.
Need your input.
Yeah. So,
Im-
we'll look it
uh,
over and, you know, continue working with y'all on it.
Yeah. What I would like to ask is everyone give input, and we'll take that and consolidate it and some ifs or ors, and we'll vote on it and move on.
And I'm for a family partition. I'm no, you know, not wanting to get rid of it by far, because,
just to let people know.
It's a blessing on a,
Yeah.
you know, a
Just to let
parent that
people
can give
know.
a kid a piece of property. It is a blessing.
Yeah, the
Nowadays.
norm is that to not have family petition. This parish has decided to help the people of the parish that would qualify and
Right.
give family petitions, which everyone believes is a good thing. In order to cut the loopholes out, you just go and treat everybody exactly the same. That is, I think, the only way you can do what Doc was saying about not giving any exceptions is to treat everyone the same. And family petition does not do that. That's a variance. That gives certain people certain benefits that other people don't get. And there's certain limitations you put on that. So we're just talking about, we're already putting limitations. So we're just talking about what limitations we're gonna settle on and try to close. I think some of the loopholes, Todd was very concerned about, especially with drainage, and it comes down to the fact, if you allow family petitions, you're not forcing people to go through the whole drainage impact thing.
That's correct. You know, you have some of these large pieces of property, don't have any parish drainage ditches. When you start busting up this property into family partitions, and their sewer has to drain to a natural, either a parish drainage ditch or a state, and you don't have them in some of these large pieces of property. So it's gonna be draining across someone's property, which / is supposed to be illegal. So, you know, some issues out there with that, you know.
Well, and certainly, none of us over here wants to make a decision that's gonna negatively impact someone, especially a family trying to get it.
But I have received some calls recently that's got some family partitions and true family partitions
Yeah.
coming up that, you know, so moratorium, I feel, I don't know, we need to be quite that aggressive just yet.
So, we'll see what happens
Yeah.
then, but some decisions need to be made, and
Well,
not
definitely.
everyone is gonna be happy with any decision that's made.
Right.
Because as it is now, not everyone is happy with the family petitions that are being put
Right.
next to their houses that have no drainage studies done, and they are in danger of flooding, so.
Correct.
Whatever we decide, there's gonna be a group of people, one way or another, that is not gonna be happy about it, so. Solomon, we may be.
Yep.
Yes, sir.
Thank you, Mr. Chairman. I'd like to thank both of my councilman colleagues, Randy, for your comments that less than 1% of these property divisions annually are family petitions. That was certainly my experience as a planning and zoning commissioner, and I came with that as a question tonight, if Mr. Compton or somebody would have been here. And then, Todd, what you said, your concern over the family petitions moratorium, and here's my problem, as I said in my opening remarks, it's pending in front of our full council just a couple days from now on Thursday. So, Mr. Chairman, is it appropriate that this committee, by motion and second and possible vote, that we ask Chairman Lohr or whoever's the new chairman going to be, I understand there's going to be an election at that meeting too, that we, or even before the fact, pull the moratorium off? Because I believe, like Mr. Lambert, it's going to cause some grief to some folks at least, until we work this out through this, which I always hear. It's important to go through strategic planning or the appropriate committee first before going to the full council. It's like 2 recommendations have come up. One of them goes right to us, and we've talked about it before, it's his time too, and now we're gonna have a third time. But the other one's going directly to the full council with locomotive speed Thursday, and I, for one, don't support a moratorium right now until we see what's gonna happen.
The proper method from getting recommendations from the planning commission is to go to the council. The recommendation of the planning commission was that the council,
I understand, but these two are tied together, so who's putting this one forward? The one we have tonight in front of us.
The planning commission is asking for a moratorium so that we can implement whatever limitations we want to put on family petitions to not have the loopholes that have been going through. And so they ask that we take this time so we can implement this so that the family petitions can continue under the new regulations.
See, it just seems to me that, like Todd said, we ought to just close the loopholes, period, versus just say, let's stop doing anything until we can close the holes. Because when you close them, then everything can just go on. I mean, at the end of 3 months, if we haven't closed them, what are we going to go for, another moratorium of X more months, et cetera? It seems like we've got this process, and I understand one group can go through this committee, the other group doesn't have to, and so forth, but common sense to me would say, let's fix this loophole law, get rid of anything that's unreasonable or unacceptable and potentially unconstitutional, and then worry about, shutting down the rights of the people to do family petitions. That's all I'm saying. And, if you'd entertain that as a motion, or if you want to just personally talk with council.
It's not on the agenda for this. This is for.
Well, it's related to this.
Yes,
This
it
committee
is.
can certainly, make, I think, motions and whatever, any way it so sees fit, on related items, right?
If you want to put revisions of the subdivision regulations and that and get this.
Ahead of moratorium, yeah, I'd make that motion, even at the risk of it dying for lack of a second. You are the chairman, though. That's your choice, Mr. Sexton.
We can say it was discussed. It's not an agenda item, Doc. I mean, I'm not trying to skirt around it.
Guess I have appreciation for that, Ken.
Lindsay, is that something?
It's not, but it's you're absolutely right, but it is related to, these two things are just inextricably linked, any way you look at it.
So, Mr. Sadler.
Even if they came from two different
You want to put
things.
this to the council agenda? Is that what
No,
I'm
he
understanding?
wants,
Just a
Councilman
recommendation
Sadler
coming from
wants
us,
to.
from our council, our committee, to the full council, that they not consider this at the next meeting until we can actually send them a recommendation on we agree with this language that's in red here on this.
Right, and I think you can do that, but it's more appropriately addressed at the meeting because the agenda's already been set and it's been advertised. So I think that might be a
Okay.
situation where you just ask the
So you're
chairman
saying
at the meeting.
Thursday night that we could just maybe, I'll probably be the one to do it then.
You might speak with the chairman before and just say you'd like to
Defer it.
make that recommendation or let him know. Or isn't there a place for chairman's reports? Maybe you could
No.
present, no, not for strategic planning.
I don't know, that's up to the chairman there.
Mr. Chairman, I will withdraw that request. We'll just handle this Thursday. It sounds
Yes.
like we'll just do it then.
It's on the agenda.
All right, thank you.
That's good.
We're set to do this. We're gonna have some input. I am wishing to err with caution with doing this. That's why we're not going at breakneck speed. But we will take information from everyone and put this down as a proposal. It may not be what everyone wants as we get these individual proposals, but we'll go down the list and vote on them yes or no and move them forward. So not everyone is going to get everything they want, certainly not myself or anybody else. But we will try to address what Todd and Randy were saying, is get this moved forward as quickly as possible. Yes.
And correct me if I'm wrong, but if this committee comes back next month and makes changes or recommends changes to the full council, you're still talking a month and a half, 2 months before any of that is finally resolved through the council. So you're still talking 3 months before any of that stuff gets done. So as far as a moratorium going for 3 months, I mean, that's the first I've heard of it tonight. Whether that goes through or not, before anything happens, at the earliest you're talking is 3 months before something like this can get through the process. and get adopted before it turns into law. So, I mean, whether you work at breakneck speed or not, you'd have to do something tonight in order to make that go any quicker than what it is. So 3 months is not something that's going to get done any quicker than what it is.
And basically what happened is the planning commission was having to, because people met certain minimal guidelines set forth as it is now, to approve some family petition that really wasn't the spirit of family petition, and they wanted the council to be able to step in and give them a chance to have harder guidelines, so that they would have a little more.
I want to make sure I understand understood what you said, Kent. Is there some looming family, not a family petition?
Yes.
Out there?
Yes.
And so this is the impetus for the moratorium in order
Right.
to prevent what we know is a loophole use? Okay, that's helpful. Thank
Yes,
you.
and there is some legitimate family petitions that are coming up that people would like to see go forward, but by law, you can't just pick and choose what you would do. So, but you can, by law, present a moratorium on everything until you decide and adjust the law so that everybody would be treated the same. So that's the intent of it from everyone. So I suggest strongly that everyone has some dialogue, continue this and move forward so that we can get something done expedited, so we can get some direction to the assist the the planning commission in there. Anything else with that, number 7?
So,
Motion
move to adjourn.
Second.
This meeting hereby adjourned.